All right, council, I think we're streaming now, so we'll go ahead and continue with the second case on the docket. I'm Judge Thomas E. Malone, presiding judge here. We also have Judge Gordon Atchison and Senior Judge Jim Burgess. We are the panel for this morning's hearings. As I said before the first case, just a few preliminary remarks, counsel. We have read your briefs. We're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As presiding judge, I'll be the timekeeper. Each one of you is given 15 minutes for your argument. The appellant's attorney should let us know at the beginning if you wish to reserve any of your time for rebuttal. After we hear your arguments this morning, your case will be deemed submitted for decision. We'll take the matter under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, the second case on the docket is from Marion County. It is number 122-682, entitled The State of Kansas versus Ty R. Zeiner. And who do we have here for the appellant?
May it please the court, Kelly Trussell, appearing on behalf of the appellant.
And the appellee?
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers.
All right, Ms. Trussell, whenever you're ready, do you wish to reserve any of your time for rebuttal?
I do, Your Honor. I would like to reserve 2 minutes, please.
That is granted, and you can go ahead and begin.
Thank you. Under Kansas law, it is not illegal to drink alcohol and then drive a car. It is only illegal when the defendant consumes alcohol to a level that makes him incapable of safely driving the car. KSA 8-1567 requires a factual determination that the defendant was driving or attempting to drive the vehicle while he was under the influence to a degree that renders the person incapable of safely driving. First, I would like to clearly state that Mr. Zeiner is not asking this court to entertain any alternative theories of his case or to reweigh the evidence. The state's brief argues that we are not keeping in line with the standard of review in this case, but that is exactly what we're asking this court to do. Evaluate the evidence in light that is most favorable to the state, and then apply the law. For this appeal, Mr. Zeiner has conceded every fact and evidence that is favorable to the state. He concedes that he drank alcohol in Strong City that night. He concedes that he drove his car to the gravel road and parked that night. He also concedes that when Deputy Starkey encountered him hours later, he was intoxicated to at least some level. But the level of intoxication he had reached at that point is irrelevant because he did not operate or attempt to operate the vehicle at that time. How intoxicated was Mr. Zeiner when he drove the vehicle to the gravel road? We don't know.
Is it safe to assume that he would have been more intoxicated then than he was when the officer approached him?
It is not actually in this factual scenario. There's two interesting points of time in this case. You've got the time that he drives to the gravel road and parks the car, and then you have when Deputy Starkey encounters him hours later. But what is interesting in this case, and factually important, is that in between that time, hours go by and there is evidence of alcohol consumption in the car. So it's not safe to assume that what level of intoxication he was at when he parked the car or what level of intoxication he was at when Deputy Starkey encountered him was all one same event, because there is a series of hours with alcohol consumption in between that time.
Was there evidence of alcohol consumption or just alcohol found in the car?
Well, Your Honor, what's important in that evidence is that there was one empty beer bottle, there was one full beer bottle, but there were also beer bottle caps missing their bottles. And what is also important is that Deputy Starkey admitted in testimony that he never searched the area around the car or in the ditch for any of those empty beer bottles, and he never asked the defendant when that alcohol was consumed. So the evidence in this record is that there is bottle caps with missing bottles. We don't know where those bottles are. They weren't looked for, and there is no evidence that he didn't consume that alcohol.
Well, these are all fact questions, though, that were weighed by the jury. And my question is simply, did your client come forward with some evidence that said, I drank while I was parked there on the road? Did he ever say that?
No, he did not, but he was also never asked that. He didn't, so the jury's evidence in front of them was, yes, he drank, he drove, he parked. There is evidence that would support it. And I think that's important because if there was no evidence that he had access to alcohol in between those periods of time, then we wouldn't be here arguing that issue because there wouldn't be that opportunity for him to have had increased his level of intoxication from the time that he parked until the time that Deputy Starkey found him. And so, yes, the jury did have that evidence in front of them, but that doesn't mean that they have the same. That really, what's important here is that they needed to have evidence to support that he drove while he was too intoxicated to safely do so. And yes, they can ignore the in-between evidence, but these two things just don't go together. You've got him driving and parking, and then you have him to a level of intoxication that he cannot safely drive. But you have to just completely assume that level of intoxication came from him drinking 1 to 2 beers at Ad Astra, which is what the evidence was. Now, on top of that, we do have a witness who was with him for an hour that night while he was at Ad Astra in Strong City, Mr. Maddox. And he testified that that Mr. Zeiner was not intoxicated that night when he was at Ad Astra. That's the only evidence in the record. It's the only evidence that the jury had. Now, the state wants to argue that Mr. Maddox himself was intoxicated that night and probably isn't a great witness for them. But that's the only evidence that was that they had. That was it. It's the only evidence.
What about the field sobriety test when the deputy took him out of the car?
I'm sorry, Your Honor. I think you broke up.
What about the field sobriety test when he took him out of the car?
Yes, there was a field sobriety test that there are issues with that field sobriety test, but we did not take that up on appeal. It was on a gravel road where the deputy told him to imagine a straight line and et cetera and things like that. But all of that happened hours after he had parked the vehicle.
But he'd failed the field sobriety test even then.
He did. He did. But again, there was evidence of alcohol, access to alcohol and alcohol consumption in between that period of time. I don't think we can fully just ignore that in this record.
So you're asking us to assume that he's 3 miles from home, stops to drink. Is that what you're asking us to assume?
He did stop. He stopped. The evidence says that he stopped because he was tired. Mr. Zeiner has an employment that takes him all hours of the day and night all over the state. And Deputy Starkey actually knows Mr. Zeiner quite well. His testimony was that it was not unusual or even odd for Mr. Zeiner, for him to believe that Mr. Zeiner would be to get tired and park on the gravel road. And interestingly, Deputy Starkey actually did not point to him driving and parking along the road that night as the elements of the DUI. He actually only pointed to the fact that he was sitting in the car with the radio on and the lights on as evidence of the DUI with the intoxication. He never testified that it was because he drove from Strong City and parked along the side of the road that night. And, go ahead, sorry.
Do the breath test results have anything to do with this particular means of the DUI, that is being unable to operate safely?
These breathalyzer results, as they go to the second issue, they can be used as circumstantial evidence. They were insufficient breath tests. They can certainly be used as circumstantial evidence to his level of intoxication. But again, Mr. Zeiner he's conceding that he was intoxicated at that point. He has to. He failed the sobriety test in evidence. He has these insufficient.
Right. I understand that. Was there any expert testimony about that level of intoxication is shown by the breath tests as it might correspond to his level of intoxication at the time he was driving? Did anybody testify, something like a physiologist or a medical doctor testify as to some relationship between those?
No, there was no expert evidence regarding any of the breathalyzer results or what we could gain from that information. It's
at least as to this means of violating the statute, then it's this abstract fact as far as you're concerned.
Yes, we have all we can take from the insufficient breath or the insufficient breath test is what it goes towards the fact that he was intoxicated at that point to some degree, and when that became a fact, we don't know. We don't know when he became intoxicated to that level. We just don't.
Yeah, you have said several times in your presentation today, and I think maybe in the briefs, that he was parked there for hours. How do we know that? I mean, isn't that speculation as to how long he was parked?
It's somewhat speculation, but it is evidence into the record. We do know that he left Ad Astra a little after 10 o'clock that night. We do know that when the Mr. McLinden, who was the first person to encounter him on the gravel road, it was sometime after midnight. He did not know exactly when. He knew it was sometime after midnight that he drove past and saw him there. His father, Mr. McLinden's father, is the one that made the phone call to the sheriff's office to check on Mr. Zeiner's, because he was along the side of the road and his son was concerned. And so Deputy Starkey was dispatched at 3:15 that morning. And so then sometime soon after that, he arrived. And so we don't know exactly how much time had passed. That's the timeline that we have in the record. But Deputy Starkey did testify that it could have been hours that he had been sitting there.
But that's speculation.
It is.
Counsel, why don't you turn to your instruction issue? You just have a couple minutes left here.
All right. Thank you, Your Honor. Yes. So Mr. Zeiner at trial requested a jury instruction to address this issue of defining operate and drive. And the Darrow Court in 2016 had defined that, or had stated that operate and drive are synonymous, and that's the definition that was requested in the instruction. That operate and drive are synonymous, or operate means drive. Both of those would be direct quotes from the Kansas Supreme Court and would be accurate statements of law. However, that was rejected to add to the pattern instruction. And not only not only do we believe that to be an accurate instruction and an appropriate instruction, but it was also necessary because of the misleading testimony that appeared in this case, and that came from Deputy Starkey. The question that was presented in asking whether Mr. Zeiner had attempted to drive or operate the vehicle while intoxicated, Deputy Starkey's testimony came out this way. The question: so you think the fact that the lights are on and the radio is playing suggests that Mr. Zeiner was attempting to drive the vehicle? His answer: no, but he was attempting to operate the vehicle. And by separating out driving and operating, this certainly misled the jury. And so this was attempted to be corrected in closing arguments, with defense counsel saying that operate and drive are the same thing. And that did occur, and defense counsel had that opportunity. However, it could not have possibly cured this problem in the trial. The appellate courts have long held that juries follow the instructions. I don't particularly know of cases that say juries follow defense counsel's definition in closing argument when it counters or is contradictory to the jury instruction. So for that reason, Mr. Zeiner did not receive a fair trial and should be given another opportunity to provide jury instructions that appropriately state the law.
All right, counsel, thank you very much. You'll still have your rebuttal time. Ms. Chalmers, we will turn over to you.
It please the court. The defendant is now doing the exact same thing that he did in his brief, which is argue the evidence in the light most favorable to him instead of the light most favorable to the state. There is no testimony by the defendant in this case that he passed out because he was so tired, and then apparently decided, instead of going home 3 miles away from home, that he was going to chug a bunch of alcohol and throw it outside of the car. No evidence supports that. It's not even a reasonable inference, and there's a reason the jury rejected it. When this court applies the appropriate standard, there's no question that there was sufficient evidence to convict this defendant. As to
what evidence is it that shows that he was driving at the same time he was too intoxicated to do so safely?
I think
those have to occur simultaneously. What is the evidence of that those occurred simultaneously?
Again, it's all circumstantial evidence because we don't have the exact time that he drove, but we do know that his blood alcohol content was very high and that he gave deficient samples, which were only partial. He left Strong City and could not make it home. Again, he passed out in his vehicle 3 miles from his home. He had, at one point, the car was indeed running when the first person came to check on him. He also, for some reason, even though the deputy repeatedly told him he couldn't drive his car, kept trying to ask to drive his car, which could be considered an attempt to drive the car once the deputy was even on scene. But yeah, it's all circumstantial evidence. We have a very high blood alcohol content, and we have no indication that he had anything to drink from the time that he left.
I'll ask you the same question I asked your counterpart. Is there anything in the testimony at trial to correlate the blood alcohol readings to some level of intoxication at the time Mr. Zeiner was driving?
No, there was no testimony that would have been helpful that would have said we backdate it. So based on this particular result, it would have been this at the time that he allegedly.
So isn't that just a random fact then?
I think it's still a fact that is circumstantial evidence of the fact that, as defense counsel stated in his closing, we know blood alcohol continues to go up once you are drinking, and a high blood alcohol, which is over it's not quite 2 times the legal limit. It's a little less than 2 times the legal limit, establishes that a few hours prior to that, he probably was still intoxicated. And again, you don't need, I would agree with you that you do not need a specific alcohol level content to convict under this version that we are attempting to do. They safely and operate the vehicle. Here again, he's passed out on the side of the road. He can't safely operate a vehicle while he is so intoxicated that he cannot keep his eyes open. If there are no further questions on that, or hopefully I answered your question, turning to the jury instruction, I believe counsel just stated that the idea that driving and operate are inconsistent with each other, and I don't think that's accurate. I don't think that.
I think it was just the reverse. She said the Kansas Supreme Court has held that driving and operating are to be construed the same, and that's how I read that particular case, the Darrow case. Is that your understanding of the law? Is that they're synonymous?
It is I disagree somewhat with that. I agree that Darrow says that. I can't get around that fact. But I think if you read Areens, that talks about the history of the statute. The statute used to say driving. The legislator then amended to say operate, which suggests very strongly that they meant to broaden it to not just driving. So I think
Areen precedes Darrow, right?
It does.
It's the earlier case. Well, aren't we stuck with Darrow?
I agree that you were stuck with Darrow, but I do find it odd that there are seeming to be conflicting Kansas Supreme Court opinions, both of which are binding.
That's above our pay grade, right?
Yeah.
Would you? And I'm not trying to offend you. You would agree that we need to apply the rule from Darrow, which clearly is that driving and operating under 8-1567 are synonymous.
I think if there's no way to make it a dicta, I don't honestly know what happens when you have two inconsistent Kansas Supreme Court opinions. I'm just not that familiar with that happening, but it does, at least in my mind, you're only bound by precedent if there's no reasonable way to think that they might change from that precedent. I'm not saying that's standard, right? But if there's no indication that they're going to move from that precedent. And I think Aaron's is the better decided opinion. And it's also binding law on the fact that and basic rules of statutory interpretation. So my point is that I think it's unclear if it's legally accurate that operating and driving are synonymous. But my point is to what defense counsel was saying is she was saying that the defense counsel at the jury trial, appellant's counsel, said was the defense counsel at jury trial wouldn't have been believed because driving and operating are inconsistent. And I don't think that's accurate as to the portion of the harmless error if you find that it should have been instructed. My point is essentially the jury doesn't need this instruction. Defense counsel said operate means drive. No one contested that. I know that the officer testified differently, but the officer is not an expert on law, and one of our own witnesses kind of conflicted with something else the officer said regarding the machine testing and what a deficient sample means versus alcohol on the breath. But the thing that the jury would have heard during closing is that operate is the same as driving. More importantly, the instruction they requested here was incomplete. It didn't specify that movement was not necessary for a conviction, which was the reason the district court judge rejected it. So the instructions here are legally accurate. They follow the PIC exactly. I don't think there was a need to, in this case, define driving or operating as driving. And I don't think, based on the Kansas Supreme Court case law anyway, that it's entirely clear that driving is necessarily operating. And if this court disagrees, of course, a petition for review can be filed to see if the Kansas Supreme Court will clarify those conflicting cases. But regardless, any error in this case should be harmless. Defense counsel, again, told the jury that operate means drive. The defense here, as on appeal, wholly lacks credibility, that he just randomly except there's a sort of a paradox in that argument. I mean, you're saying that defense counsel was wrong to tell the jury that. You're saying that's not the law. Well, but it's the only law that the jury heard. So they would have had no reason to go with anything other than the defense counsel saying that was the law. Whether or not I'm right or wrong about it being the law, that's the only law that they heard.
Other than the very logical rule of statutory construction that even lay jurors would apply is if the legislature meant drive, they would have said drive, and they said operate, and maybe having the radio on is operating the car. Is that a reasonable conclusion the jury could have come to?
I don't think the state ever argued that just because the radio was on, that's why we're driving. We went with the fact that he drove from Ad Astra to where he was found and passed out and couldn't make it. We didn't argue just because the radio was on, but it wasn't just because the radio was on, the car itself was on. But no.
Well, not at the time the officer got there.
I'm sorry? Yes.
Not when the officer got there.
Well, before the officer got there, the car itself was actually on. The engine was running, according to the testimony. But I don't think a jury would sit there and say rules of statutory construction, which they're not at all versed on, that drive means drive and operate means operate. I think.
Well, I agree that they would not have put that label on it, but I could see a juror saying, well, drive and operate aren't necessarily the same thing. If you have, I mean, the radio on is arguably operating the car in some manner. It's operating the instrumentality in the car. That doesn't seem to me to be wholly unreasonable under these circumstances, given that that's the word that's used. And you would submit that it would have been wrong for the district court to include some kind of definition that says operating means driving. Right?
I think the issue below, honestly, I wouldn't have cared if they had said operated means driving, as it would have gotten rid of an appellate issue. But what I do think that Aaron's is, I don't know how to say that case, Aaron's is the better case for that. I think that the legislator did intend probably operating to be broader than driving. And then in which case, yeah, the instruction shouldn't have been given. But based on Darrow, if they'd given the instruction, they should have added more to it. And the problem wasn't so much with operating meaning driving, which no one ever argued that it didn't. And in fact, the prosecution was told they could not argue that operating did not mean, or that, yeah, operating meant anything other than driving. I lost my train of thought there. So back to the instruction. I still think Aaron's is wrong, but if they wanted to give that instruction, they needed to finish it. They needed to say movement isn't necessary. And that's the problem we have with the instruction they requested, is it was incomplete. And the district court shouldn't be found to be in error for giving an incomplete instruction. But here, even if there was some kind of error, the error here was harmless. The defense idea today and at the district court, which has no support by their own client, that he just, again, got so tired and then decided apparently while he was super tired to drink a bunch and then pass out on the side of the road, is nothing a jury would ever buy. The evidence in this case was strong, if not overwhelming, based on the fact of his high alcohol content, the failed sobriety test, his repeated attempts to try and drive the vehicle. And I would just urge this court to watch the video. There's no question he was intoxicated. And I think defense counsel even admitted he was intoxicated when he was stopped. So for those reasons, the state would respectfully request that this court affirm the defendant's conviction.
Counsel, thank you. We will go back. You still have your 2 minutes of rebuttal, Ms. Trussell.
Thank you. The Darrow case and coming to this conclusion and definition that operate means drive, I don't think it's overly contradictory to the Aaron's case. The point in Darrow that the Supreme Court, in my opinion, was trying to make is that operate and drive go together, in that the definition of operate means it has to be some sort of action that would drive the car. In other words, in Darrow, she reached for the gear shift. That would be an overt act in an operation that would drive the car. Had she reached for the radio knob, that might have been a different conclusion. And I believe that the court would have found a different conclusion, that operating would have to be somewhere in the lines of driving the vehicle, something to do with that, not turning on the headlights, not just running the radio. So I don't think that the Aaron's case and the Darrow case really contradict each other. I think Darrow just makes it very clear in plain and simple terms that in order to have operate, you have to have some sort of action that would drive the vehicle. And so that's.
So what about attempt to operate? You don't have to have movement to have an attempt.
No, you do not. Darrow also makes that clear. You have to, in order to satisfy attempt, you have to have an overt action. that would cause operation of the vehicle. So in Darrow, she didn't actually put it into gear. She just reached for the gear shift. That's an overt act toward operation of that vehicle. That does make it an intent. And so, and in this case, all we have is the radio on and the lights on. And so from the
No,
point
you
of,
don't. You have a witness who said the engine was running.
yes, and I'm sorry, I meant from the time that Deputy Starkey encountered him, that's all we have from there forward. And so I don't think there's really much of an argument under Darrow that he ever attempted to operate that vehicle from the time that Deputy Starkey came to encounter him. So really the argument is all the way back to this gravel road where the engine's running and he's sitting there. And even then, he still makes no attempt to operate the vehicle at that point. Just sitting behind a running car does not satisfy operate.
So you're trying to say that the civilian testimony that the car was running is irrelevant? It only matters what the deputy saw?
No, I'm not saying that at all. I'm saying that him simply sitting behind a wheel of a car with the engine running, that is not enough to satisfy Darrow, because that's the whole reason why Darrow came to be. The defendant, she was sitting in a running vehicle, and why did they take that analysis then to be, well, but was she operating? Because they didn't know who had started the vehicle. They didn't know if she had. Obviously, in this case, if the car was running, we're not going to argue that he hadn't started the vehicle, but we don't know what level of intoxication he was in, and that is the burden that the state ignores in this case. They had the burden to show that he was intoxicated to the level to unsafely operate that vehicle. And the only time, or I guess the time where he stops operating that vehicle, is when he parks on the side of that road. And up to that point, at that moment in time, that was where the state's burden was. They had to prove he was intoxicated to a level that it was unsafe for him to operate the vehicle when he parked on the gravel road that night.
All right, counsel, you've actually used more than your time, so that's all right. You were answering a question, but with that, we'll deem the case submitted for decision. We'll get a written decision out to you and your clients just as soon as we can. We thank you for your briefs and your arguments.